We begin with Mr. Aldama's defense. To respond, to support, or oppose the claims.
I will be brief. I will only respond to some that we consider affect us. Starting with the issue of jurisdiction, the perpetuity of jurisdiction is, this court considers that this is the competent tribunal in an unequivocal way. In our opinion, being subject to special jurisdiction can never be considered a reduction of guarantees, but rather it is a privilege which precisely grants a guarantee to the person with special jurisdiction. That is indisputable. We see that it is a court made up of 7 justices from the High Court, and there is no greater guarantee for the person with special jurisdiction than being judged by this court. This is an issue that has already been raised on several occasions. It's not just about reading the agreement from the full court session with just a few lines, but that agreement has later been reflected in several judicial rulings. The ruling cited by the defense, 869/2014 from December 10th, addresses this issue in detail, stating that certainly it is an issue that has not yet received very detailed regulation from the legislator, as this very court has been requesting. The truth is that it was necessary to resolve what happens in those cases where indeed the special jurisdiction is lost, but after the order to open the oral trial. In our opinion, there is a provision that supports this situation, which is Article 783.2 for the abbreviated procedure and the purposes of the order to open the oral trial. And among those purposes precisely is the determination of the trial court. When the law allows, in this procedure, to challenge jurisdiction, it is because it will be possible to discuss whether, at the time the order to open the oral trial is issued, there is a cause for nullity or not. But not when the order is issued. It is indisputable that Mr. Abalos has special judicial status. There is no cause for nullity regarding a possible erroneous determination of jurisdiction. Mr. Abalos is a member of Parliament both when he commits the acts and when the order to open the oral trial is issued. And subsequent circumstances, which in this case have also depended on the will of the person with special judicial status, cannot affect the final determination of jurisdiction to judge. This is not a contingent circumstance, and much less something that can depend on the will, in this case, of one of the accused. I believe this matter has already been decided. It's not about the possible compatibility of a jurisprudential agreement with a regulation. The regulation exists, which is the criminal procedure law. When it determines the scope of the order to open the oral trial, the agreement is still complementary, according to the role that jurisprudence plays to the scope of that regulation. Is there a pre-constitutional regulation that cites a resolution from this High Court from 1912 which says that whatever may happen with the Parliament will not alter the jurisdiction and competence regarding the person with special legal status? Therefore, of course, there is a legal basis. It's true that it would have been more enriching to have a direct mention from what is called parliamentary criminal law, but we believe that the criminal procedure law already settles this matter sufficiently, supported by case law. Therefore, this party opposes declaring the lack of jurisdiction of the Supreme Court. And also the preliminary question, which is also not applicable, but we believe that there is no reasonable doubt. It is a matter that has already been resolved in an unquestionable way by this court. Therefore, if no doubt is raised, in our opinion, it is not mandatory to raise any doubt either. There is no preliminary question on this matter. The issue of the jury court, very briefly. Cases that fall under the jurisdiction of the National Court are specifically excluded from the jury court law. So, it's paradoxical to request that a case be sent back to the National Court, since it would never be a case that could be tried by the jury court. And to try to implement a jury in the Supreme Court, which is obviously not provided for by law, therefore we oppose that request. I'm not going to comment on other issues that don't concern us, except for the last one, the so-called entity or collaborator, or the request to make explicit a possible plea agreement. We are even told that there has been a lack of transparency regarding the actions taken. Look, there is no plea agreement. Your Excellency, Mr. President, he asked us at the beginning whether or not we agreed with the indictment. We agree with the facts stated in the indictment. We disagree regarding the legal and criminal consequences, and we even partially disagree with the facts presented by the private prosecution, although regarding the essence and everything that coincides with the public prosecutor's office, we have already expressed our wishes in writing. What Mr. Aldama has done is simply a procedural action that is provided for in the law itself, in the criminal law. We're charged with criminal organization. Article 574 of the Criminal Code, which we have not mentioned in our provisional conclusions, but we will. In the end, it establishes a reduced penalty for the defendant who is charged with the crime of criminal organization, who contributes in agreement and cooperation with the authorities to dismantling that organization, to identifying its leaders, and to uncovering the acts attributed to that criminal organization. And this is what Mr. Aldama has done. It's not about signing a shady agreement with the prosecutor's office. It's about taking advantage of a criminal law that, of course, grants him penal benefits, because that's what the current criminal policy wants, to encourage behaviors of this kind. So, far from violating any fundamental rights of other defendants, what this defense has done on behalf of Mr. Aldama is precisely to protect his rights and take advantage of a favorable criminal law, which, according to the current parameters of criminal policy, encourages, in accordance with the New York Convention, also the fight against corruption, etc. There will be time, if necessary, to talk about it, but obviously it must be absolutely rejected. The mere claim of being a pentiti implies, we are told, the acknowledgement of the existence of a criminal organization. Because precisely the pentiti is the one who decides to cooperate with justice and dismantle and put an end to that criminal organization. This is this party's procedural position. Consequently, this preliminary issue, of course, must be rejected. It is already anticipated. It does not exist. There is no agreement at all. It is also anticipated that Mr. Aldama will respond to each of the prosecutors and defense attorneys with complete transparency. And he will answer, in order not to cause any lack of defense, to as many questions as they want to ask him. I believe that for my part, and given the standing I have, I don't think I should answer any other questions. That's all.